In this video, I'm going to talk to you about the importance of formally resolving the financial matters when getting divorced and the potential implications of not doing so, particularly when it comes to remarriage. In the United Kingdom, a marriage is legally dissolved once decree absolute is pronounced by the court. A key issue I keep coming across is that lots of people mistakenly believe that once they have decree absolute, that all matters have been dealt with regarding their former spouse. This is not the case. The financial matters also need to be dealt with, and they are dealt with separately to the divorce proceedings. The financial claims spouses have against each other remain open until either an agreement is reached and the agreement is approved by the court, or the court decides what is to happen regarding the financial matters. For the court to approve an agreement, it needs to be recorded in a document called a consent order and filed at court for approval. This is what makes the agreement legally binding. I often assist with the drafting of the consent order, and usually court attendance is not required for the court to approve the documentation. Potential consequences if financial claims are not formally dealt with include that a former spouse could seek to make a financial claim many years after separation. There is no time limit in this respect, and it can be far more complex and time-consuming to deal with matters many years down the line, particularly, for example, where the value of assets might have increased significantly. Another issue that can arise is that you may think an agreement was reached with your former spouse, either verbally or written down on a piece of paper. However, if the agreement was not approved by the court, thereby making it legally binding, you may find matters unravel and need to be considered further at a later date. Unless certain criteria are met, it can be very difficult to say to the court that an agreement has already been reached and matters have been concluded. Another issue that can arise is that if you remarry without ensuring the financial matters have been dealt with, or at the very least, steps have not been taken to protect the financial claims that can arise, the person that has remarried is unable to ask the court to make an order regarding there being a transfer of property, a lump sum, or maintenance in their favour. This is known as the remarriage trap. Orders regarding pensions can still be made, however. If remarrying, please consider the following to protect yourself and obtain legal advice at the earliest opportunity beforehand. Firstly, the most straightforward thing to do would be to ensure the financial matters have been resolved prior to remarriage. If that is not possible, we need to look at the divorce petition. If you were the one that filed the divorce petition in the divorce proceedings and you are remarrying, you must ensure the relevant box was ticked in the divorce petition to say that you wish to apply for a financial order. Ticking this box does not mean that court proceedings are commenced straight away, but leaves the door open should this be required at a later date. If the relevant box was not ticked in the divorce petition, before remarrying, an application would need to be filed separately to commence the financial proceedings. If you were the one responding to the divorce petition, you must make an application to court to commence financial proceedings prior to remarrying. It may then be that an agreement can be reached during the court proceedings. I would therefore stress the importance of ensuring financial claims are dealt with, and the best way to ensure this is the case is to obtain legal advice at the earliest opportunity.